Marcas contrarias al orden público y las buenas costumbres. Octavio Guerrero, gerente de propiedad intelectual en Grupo AlEn, México.
Octavio Guerrero, manager of
Alejandro Fernández,
Mexico.
socio en Akerman LLP,
member of
Estados Unidos.
Akerman LLP, US. Desiree Russo, Trademark Council in Puma SE, Germany. Moderator, Hernán, Ríos, member of by partner of Marks and Clerk, UK.
Hola.
Hello, good morning. Thanks for being here. We will start with our first panel member, Desiree Russo. She's Trademark Counsel in Puma SE, and she combines a sound experience, legal experience with deep vision for brand protection in the global market. Desiree has a BA for companies and management and a master's in European legal studies. She started her career in two IP legal firms, law firms, before getting her job in the prestigious Magister in Alicante. I have also participated there together with some colleagues here. Specialized in IP. Her path through EIPO, the first room of resources as part of Europe Pearson program. She has perfected her skills on trademark and European law, international strategies of paying. Today, she protects one of the most iconic sports brands in the world, making sure that the distinctive signs are kept as dear and protected as the athletes that represent the brand. Please, Desiree.
Buenos días a todos. Espero hayan descansado.
Good morning, everybody. I hope you had a good rest. It's a pleasure for me to be here to talk about trademarks contrary to morality and public orders. I love this topic because I studied this topic when I studied in Alicante. Just to start this trip, I would like to start analyzing the regular framework of reference in the European Union. This means Article 7.1f of the brand regulation of European Union that prohibits the registry of brands or trademarks against the public order and morality. This has to do with the Paris Agreement that considers the consideration of brands contrary, of trademarks contrary to public order and morality. But how can we define public order, morality? Unfortunately, today I cannot give you a univocous answer because it does not exist. The notion flows, they change, they evolve throughout time and space, and many times they are confused, they are confused, or they overlap. They are mixed up. We could define public order as the body of legal regulations necessary for the operation or for the proper working of a democratic society and study of law. This public order has to do with the legislation of European Union, for example, treaties. Public order covers universal principles such as solidarity, equality, freedom, democracy, and the state of law. And morality, good habits, as a metaphor, we could define good habits as the invisible manual that everybody knows, but nobody has read about it. What are good habits? These are the behavioral regulations accepted by society at a certain time. Of course, this notion brings about subjective feelings, but the examiner should always assess in the most objective possible way. Finally, morality. Morality covers all social values, cultural values, philosophical, religious values, in this case of the European Union, and principles such as honesty, integrity, justice, respect, empathy. Allow me to say that those concepts that we have seen have nothing to do with an ill taste. A sign could be ill taste when maybe is coarse or gross, but not offensive necessarily. It's very important to, in order to understand those key concepts, it's important to always analyze the reference public. Could be not only the target public of products and services protected by the application of the request, but the public in everyday life they could face those signs. Also, mid-consumer, average consumer is the reasonable person with mid thresholds of sensitivity and tolerance. This means we should not assess the perspective of a small minority that could be too strict, and on the other side of the spectrum with certain morality issues. Now, if we get into the relevant jurisprudence, I would like to start talking about a case that has revolutionized the branding, the trademark situation in Europe, and the Article 71F. This has even revolutionized my last stage of master, because this was defined the justice in February 2020 when I was writing my thesis. Fuck You Goethe is the title of a German movie of Constantine that was very successful in Germany, and the company has to ask for this title of the movie as a trademark. WIPO rejected this trademark because of the contrary, because of the morality and trademarks contrary, because Fuck You Goethe offended the German author Goethe, and absolutely vulgar defamation. The company presented resources of the European Union, left the resource aside. We get to the General European Union Court, again was set aside, and finally we got to the Justice Court. Back in February 2020, finally the ruling was in favor of the brand, of the trademark. And the arguments were very interesting. I would like to share them. First, we should always analyze the social and cultural environment, the context, in this case, the German context, a context where that movie and the expression Fuck You Goethe has contributed to significant controversy. Also, as we have seen, the perception of the relevant public is very important. For the German public, Fuck You Goethe has never been considered as an offensive expression, but as something ironic or a play-like thing. Let me underline that this movie was also used by Goethe Institute globally in their educational and promotional campaigns of the language and the German culture. Also, it's important to highlight the importance of the assessment of language itself. Not only the morality and public order concepts, they evolve throughout the time, but also the language changes, and expressions such as fuck or fuck you, they don't have this negative connotation that might have for our grandparents or our parents. So the court has concluded that we should always implement a global analysis, integrated analysis, to consider not only those factors, but a simple analysis, not to consider those. That ruling, that decision generated a very important debate, and this was in general terms considered as victory for freedom of speech and expression. I would now like to talk about a case that has affected me, not only as a professional, but personal in the trademark law, but as an Italian citizen. This is the case of La Mafia Sits Down at the Table. This is the name of a chain of restaurants very popular in the Iberian Peninsula. And this expression was registered as a brand, was filed as a brand. However, as a brand in the European, as a trademark in the European Union. However, the Italian government, and I add, unfortunately, fortunately, they presented a nullified decision because of the fact that it was contrary to public and morality that has always been accepted by WIPO and the General Court. Advanced arguments by the Italian government accepted by the General Court, they are very deep and very interesting. First, La mafia se sienta a la mesa is an expression that paralyzes, that degrades and denigrates, rules down the perception of la mafia, the mob. We should not forget to disregard that this la mafia is a criminal concept. They still produce crimes in the whole world, not only in Italy. So this concept, they sit down for restaurants, this means relaxing entertainment, but this constitutes a great offense to the moral consideration of the European Union. Also, and I believe this is very interesting, the Italian government and also the General Court has also accepted this. This brand could make up a serious damage to the reputation of Italian cuisine in the world. I believe all of us agree on this. I'm not saying this because of the fact that I'm Italian, but Italian cuisine has an extraordinary reputation globally. So this brand would constitute a very serious offense and a very deep consideration or affection against that reputation. I would like to conclude with this analysis of relevant jurisprudence with the case of Pablo Escobar. The brand of the request of Pablo Escobar was submitted as a brand of the European Union for many different classes of products and services. And this was rejected. The General Court confirmed the denegation or the rejection of that brand. Why? Because Pablo Escobar, in this case, the perspective of the Spanish people was adopted. This is considered as related to a negative image, narco-terrorism, drug trafficking. So it cannot be, again, assessed to the spiritual and moral heritage of the European Union. And allow me to underscore, as the General Court did, that this is not considered vulneration to the principle of innocence. It is not a judiciary condemnation. The court based only on the public consideration when they rejected or denied that brand. Here I have some print screens of the website of the restaurant La Mafia. The mob sits down at the table, se sienta a la mesa. Despite the nullity of the registry, it is still present in almost all Spain, even in the heart of WIPO and the jurisprudence in Alicante itself. And the brand is still in force in Spain, Andorra, and Mexico. So this leads us to some considerations. If we continue with our trip in the world of brands, trademark contrary to the public order and the morality, I would like to mention something about protection of expression in U.S. and Europe. I don't want to say much about U.S. because I don't want to spoil the coming presentations, but I would like to say simply that in the U.S., freedom of speech is protected by Article the First Amendment of the Constitution that prohibits the Congress to pass laws that restrict freedom of speech or press freedom. As we can see, the attitude of the United States has changed a lot. On the other hand, European Union freedom of speech is related by the Article 11 of the Fundamental Rights and the Article 10 of the European Agreement of Human Rights, without any interference by public authorities and without considering borders. Restrictions to freedom of speech is admitted to protect public order, public health, democracy, the rights and reputation of others. Trademarks contrary to public order, morality, and good habits are brands or trademarks that are uncomfortable, they are provoking. So I have included some examples here of the denegation or rejection by WIPO. And well, you can have your own considerations. On the other hand, here are some examples of trademarks. I would like to stop here on the very first one, the puta madre 69, because expression fuck you, the same as the puta madre, this is considered as a synonym of a trendy thing or a cool thing. Also, air curve as a trademark of contrabando, as another trademark, mafia clowns. I got quite surprised. Nobody presented an action to the Italian government, and marks such as Sky COVID-19. Talking about COVID, I would like to introduce a topic to conclude with my presentation on the tragedy trademarks and the trademarking the tragedy. This means requesting for trademarks related to negative situations or just to leverage the emotional impact and public attention of these tragic situations. Of course, this will lead us to ethical considerations and moral considerations because these requests sometimes dilute and degrade the tragic impact of those events. Some examples of brands that have trademarks that have been rejected in this field: White Lives Matter, or Zelensky, Knowing My Name, Covidiot, MH17 or MH370, the acronym of the famous Malaysian Airlines that have disappeared. So how can we conclude those considerations and this presentation? I believe that we cannot offer a univocous definition of the concept of morality, public order, and good habits. In this case, WIPO and the European courts, with their jurisprudence and their cases, they are trying to implement a jurisprudence that is the most consistent and coherent, as consistent and coherent as possible. And I believe the office and the courts are giving different clear guidelines in this regard. Of course, we should always implement an analysis case-by-case, a case-by-case analysis. And of course, in the field of brands trademarks contrary to public order and good habits, they are not only distinctive messages, but messages that go along society. So when they affect public order and good habits, they become a collective order. As professionals on trademark, we have the high responsibility of keeping high standards of morality, and denegating or rejecting a trademark because of the fact that it's contrary to public order and morality is not censorship, but protecting the dignity of the society, guaranteeing that entrepreneurship guarantee is always the engine of progress and not the source of degradation. Thank you.
Muchas gracias, Desiree.
Thank you, Desiree. Our second speaker is Octavio Guerrero Martinez. He is an attorney specialized in intellectual property with over 15 years of experience. Currently, he's the IP manager with AIEN Group. Is that correct? And he leads the Global Marks, Patents, and Industrial Secrets unit. He also worked at the Mexican Institute of Intellectual Property. He has been acknowledged by World Trademark Review and WTR 300 and global leaders. And he has headed strategic projects such as the project Fame Statements for Iconic Brands in Mexico. The floor is yours. Thank you, Hernán. I'd like to thank ASIPI for this invitation to talk about a controversial and interesting topic. Trademarks that may be considered contrary to public order and morality, and the limit of censorship. What trademarks can register without exercising or without restricting freedom of speech that we all have, since this is a fundamental right that should not be restricted by any government or authority. So I think we have to find an intermediate ground where we are not affecting third parties' rights and where we're not affecting freedom of speech. I'm going to focus on some cases we have dealt with in Mexico and what we're seeing in our country. In Mexico, the law has recently been amended. We used to have a section that specifically banned the registration of a mark or a brand that was against public order and morality. But some years ago, this was taken down, and we're only left with a regulation in Section 1 that says that this is a public order law and a general prohibition that no patents or marks will be registered if they are against public order or break any legal regulations. Specifically, in the chapter of trademarks, we do no longer have this prohibition that the authority cannot reject a mark that goes against public order and morality, but we do have Section 12. There is quite a discussion in Mexico about the scope of public order, the extent of public order, and whether this concept may get to reject a mark that goes against morality or that refers to crime. Over these last few months, the courts have been considering this as public order. But since this is quite a wide concept, it may fit there, but some lawyers also said that this is too wide, too comprehensive, and we shouldn't be including morality, public order in a concept that is more related to protecting the population or general order. In 2016, with a case in Mexico where somebody tried to register the brand Pinche Gringo. Pinche is a pejorative word. It's offensive. And INPI said, I cannot grant you this mark because it is offensive. The individual went to the court, and the court and the defense, the court said this mark is being registered for a restaurant. Class 43, and the term pinche also means chef's assistant. So my expression is not offensive towards American people. It is just referring to a person who assists the chef in the kitchen, and this is for a restaurant, and I'm requesting this trademark for my restaurant. Eventually, the decision was made to register that brand, and it was considered that the goal was not to be offensive towards American people or American individuals, and it specifically referred to restaurants, kitchen, foods, and beverages. There was another case, a person tried to register the term mota. For those who don't know this, it is a synonym or a way of defining marijuana. And they tried to get class 34, which is a class that includes all products related to cigarettes and smoking devices. The INPI rejected this because it said that this refers to the consumption of a banned substance. It's banned in Mexico. The case went to the administrative court, and that court confirmed that the term mota, that is marijuana, well, people may think that products that are going to be offered in the market are produced using marijuana, cannabis, or any illegal substance. So this may be considered apology for crime, and the mark was rejected. There was another very well-known case. One of the best well-known drug trafficker, Chapo Guzman, in 2010, Chapo's daughter filed the El Chapo Guzman mark in several registries, several classes. INPI rejected that, arguing that it was the name of a drug trafficker that was sought by the police, and they were not able to grant that registration. I was surprised for the fact that the INPI did not request at the time for the Chapo's daughter to say that she was the daughter of a drug trafficker. The case went to the administrative court, and the court said that this is the name of one of the most wanted drug traffickers right now, and they said Chapo means a low stature person. That's what the defense said. It comes from the term chaparro. So INPI and the court opened up the door so that eventually Chapo Guzman's daughter filed a new request, but only for the Chapo brand. She did away with the family name Guzman. INPI rejected this again, and they said, no, this is a drug trafficker, this is apology for crime, we cannot grant this registration. But when the case went up to the second court, to the administrative court, they said, well, Chapo may mean a low stature person. It may have different definitions or contexts, and consequently, we cannot assume that it refers to this drug trafficker. So the court requested INPI to grant this registration. Now, what happened eventually? The brand went out to the market. Chapo Guzman's daughter launched a clothing brand with the image, a picture of her father at the fashion show in New York, and she was using her father's face without any kind of design, and now she's legally authorized to use the mark El Chapo, but she's combining that with her father's face on it. And in this case, they did find a way to break the system, so to speak. They found a way to register El Chapo, meaning that it was a low stature person, but they combined this with a Chapo's face. And I think in this way, they are committing apology for crime. We are accepting or promoting drug trafficking, since we're considering drug traffickers as a role model. And I think this is something that should be studied, and the INPI should be able to do some research and see how the brand is being used and what's being done before granting registrations. Obviously, we may request annulment, but we need to have the legal interest to do that. And if intellectual property says that I need to have a specific interest in order to reach annulment, this may make things more difficult. INPI may start to do this, but we need a courageous person to do away with this Chapo Guzman mark. There is another case of another Mexican drug trafficker, the first drug trafficker, best-known person, Miguel Ángel Félix Gallardo. If you have seen the Narcos series, you may know who he is. In this case, the brand was requested by Miguel Félix Gallardo, omitting the name Ángel. INPI did not say anything about the name, and they quote a previous registration regarding the term Gallardo. They said there are other registrations using the term Gallardo, and the defense only said my brand is different because it contains these other words, and they never say, hey, this is my name and I have the right to use my name as a brand, as a mark. The defense never says it. They only say this brand is different from the ones you are mentioning, and INPI eventually accepts this brand. In this case, we do not see that there is real commercial use of the brand. And even after the amendment in Mexico, we see in the files that there is a request to submit declaration of use of the marks or brands, but we do not see a real use of the product for requested classes, which were clothing and alcoholic beverages. This does not mean that this may not happen in the future, but I think the case is different from Chapo Guzman's case, where there is a real use of the brand. To conclude, I think that we have to find some balance. We have to do deep analysis of the trademarks and see whether trademark and requesting, as Desiree said, in this modern context, they may no longer be offensive. They may be registered, but maybe we should not be doing apology for crime in the case of drug trafficking. The INPI is not the morality police. This is something that the government should do through education, schools, so that children will not grow up thinking that a drug trafficker is a role model, similar to soccer players such as Messi or Ronaldo. Children grow up having them as role models. We should not tolerate this. We should not accept this. We should, without getting into censorship, every case should be analyzed individually. In the case of Pinche Gringo, the products or the services may give me a better idea of what the mark refers to. So this is what we should do before determining whether it goes against morality and public order. Thank you very much.
Muchas gracias, Octavio.
Thank you very much, Octavio. Our next and last speaker of this panel is Alejandro Fernández, certified by the School of Lawyers in Florida as an expert in IP law, and a distinction that he has kept for almost 20 years. He has represented customers in all the stages of federal litigations, of brands, trademarks, patents, commercial secrets in all United States. Alex has broad experience in the trademarks and patents registry and the due diligence, corporate due diligence related to IP. Considering the most important aspects of his career, well, he has worked in Rodriguez Anderson in Madrid. He has filled a full period as in the committee of the School of Lawyers in Florida and the field of IP. He has had a scholarship with Judge Randall Rader in the Court of the Federal Circuit, and he has founded the office in Florida of a National Office of IP. Also, Alex feels a great passion for teaching English as a second language to immigrants in the United States. Alejandro, please. Good morning. I will talk to you about a dramatic change in the United States regarding the brands that have to do with public order. But if you allow me, I will make my presentation in English.
Trademarks, immoral, scandalous, and disparaging marks. They are the subject of a dramatic change in the United States. They began with a statutory framework, the Lanham Act, and the Lanham Act was set forth the framework for restrictive trademark protection, meaning that they prohibited the registration of immoral, scandalous, and disparaging trademarks. And that came into conflict with, as my colleague said earlier, the First Amendment of the United States, which protects the freedom of speech. So let's start with the statutory framework. It restricts at least three things: immoral, scandalous, and disparaging trademarks. And each of these was in the 1946 Act, which was signed by Harry Truman. And the immoral and scandalous components actually go back to 1905, so more than 115 years of this trademark law in the United States. That trademark law came into conflict in roughly 2017, so almost 115 years after the enactment, it came into conflict at the Supreme Court of the United States, and it was ultimately struck down, or at least components of it were. So the next part, we have the statutory framework, and then we have the First Amendment, which is sacred in the United States. And the First Amendment states that Congress shall not make any law that abridges the freedom of speech. So you cannot restrict freedom of speech in the United States. That is the First Amendment, and that's a matter of primacy. It's the most important law of the land in the United States. So you can see how the freedom of speech immediately came into conflict with the statutory restrictions of the Lanham Act. The first part that came into conflict was the disparagement clause, and this came to the Supreme Court in 2017. It involved an Asian group called the Slants, and Slants is a very disparaging and pejorative way to refer to Asians. But this particular group, they were Asians, so they had appropriated the very slur that they were trying to register. The Patent and Trademark Office refused registration on the basis that the mark was disparaging, and it ended up in the Supreme Court. So the Supreme Court focused on the breadth of the disparagement clause. Is the disparagement clause narrowly tailored to protect a specific interest? And in this case, the court said, no, it is not narrowly tailored. It is way too broad to limit discrimination. So Justice Alito penned the decision for the Supreme Court. It was very interesting because it was a unanimous decision. Every single one of the Supreme Court justices agreed on the point that this 115-year-old law was in fact unconstitutional. And the reason for it was overbreadth. Justice Alito wrote, "The clause reaches any trademark that disparages any person, group, or institution. It applies to trademarks like the following: down with racists, down with sexists, down with homophobes. It is not anti-discrimination. It is a happy talk clause. In this way, it goes much further than is necessary to serve the interest asserted." And of course, the interest asserted there was the disparagement of other human beings. So they found that it was simply too broad. So this basically destroyed or eliminated it found unconstitutional the Lanham Act component relating to disparagement. And that leaves two more, the immoral and scandalous ones. And those were addressed in a single case, Iancu versus Brunetti, which came before the Supreme Court in 2019. It related to the F word, and in particular, the past participle of the F word, F-U-C-T. This went to the Supreme Court after being refused registration at the Patent and Trademark Office, and the primary issue was whether the immoral and scandalous clause provisions violated the First Amendment, much like the disparagement clause. And no surprise, the Supreme Court said that it did violate the Constitution. And in this opinion, which was penned by one of the more liberal justices, so the first one was by a conservative justice. This Brunetti case was addressed by Judge Kagan, who's one of the more liberal justices, and she also found it unconstitutional, not surprisingly. She said, put the pair of overlapping terms, immoral and scandalous, together, and the statute on its face distinguishes between two opposed sets of ideas, those aligned with controversial moral standards and those hostile to them, those inducing societal nods of approval and those provoking offense and condemnation. The statute favors the former and disfavors the latter. Love rules, always be good. Registration follows. Hate rules, always be cruel, not according to the Lanham Act, immoral and scandalous bar. So on this basis, the Supreme Court overruled the immoral and scandalous component of the Lanham Act. That effectively wiped out everything except deceptive marks. So at this point, nobody has challenged that component of the Lanham Act. So where does this leave us now, 2025? Well, Brunetti has been fighting over the F word for the last 10 years. It's interesting, his original application is now before the the Patent and Trademark Office. Last year, it was refused based on a failure to function requirement. So it was it's quite a long and difficult history that it's had, even though the Supreme Court has already blessed the fact that he can register the trademark under the Lanham Act. He still hasn't been able to. This was appealed to the Federal Circuit, and the Federal Circuit addressed the issue of failure to function. So instead of the Trademark Office refusing the trademark because it was immoral or scandalous, they found a different reason. They said, well, it's too common. This is just a normal word that can't actually function as a trademark. And before the Federal Circuit, the court said, we conclude, and this is Judge Dyke at the Federal Circuit, we conclude the board failed to provide sufficient precision in its rationale for why some commonplace words can serve as a mark, but others, such as the F word, cannot. The board's lack of clarity in this regard is especially troubling given the increasing number of failure to function refusals in recent years. So it seems that the Patent and Trademark Office does not want to register these marks that are immoral and scandalous, and they're just looking for a different way to refuse them. Now, where does that leave us, and what can I tell you about registering marks in the United States? I would suggest that if you have a trademark client that wants to register a mark that is, whatever filthy, vulgar, disgusting, putrid mark, whatever degenerado mark, feel free to tell them to go for it. The United States currently has no prohibition, so the sky is the limit. And if you can think of any terrible word, anything offensive, disparaging, and truly against public order, and look it up on the Patent and Trademark Office, even as I speak, you will probably find it has been registered, or somebody is currently attempting to register it. So while the United States started out with a very well-defined and restrictive view of trademarks, at the moment it is the Wild West, and anything goes. The only bit of caution that I would add is that the mark still has to be distinctive. So when you file an application, you should consider how you are going to establish that it is distinctive. There's several things you can do here to avoid a high likelihood or to avoid a failure to function refusal. Number one is file actual use trademarks and include with it, robust specimens that show use. I know it's sensitive, but to the extent it's possible, maybe even provide sales figures in response to a refusal, and identify the number of customers that your client has had. Also, any evidence of recognition as a source indicator would be helpful. So consumer surveys, I understand these are extremely expensive, but it goes with the territory depending on the nature of your client's trademark application, how important it is. For less important ones, you might even provide a declaration from your client or from their marketing individuals or industry professionals. Any evidence of exclusivity, and lastly, any media coverage that your client has received would be helpful. So, thank you very much.
Les damos las gracias a los tres panelistas.
I'd like to thank the three speakers, Desiree, Octavio, and Alex. And we still have a few minutes left. So are there any questions from the audience for any members of the panel? Or otherwise, you can ask your questions over a cup of coffee later. Hello, good morning. I'm Virginia Melgar, President of the OIP organization. Thank you for your presentations. I'd like to add 2 comments, especially about Desiree's presentation. What the Court of Justice did in the Facu Goethe case led us to having to decide how we were going to balance freedom of speech. We do not have the U.S. case law with the mark protection law. So we have 2 post-Facu Goethe cases. One is Covidiot, mentioned by Desiree, and then we have the Maricón Perdido sentence for a comedy mark. Both were adopted, so they are binding for the first court. In Covidiot, we try to define how to balance freedom of speech with the right, exclusive right to a trademark. And we have the sentence of the U.S. Supreme Court. So in our office, we organized a meeting with all European Union trademark organizations, and we reached an agreement on how to apply the public order and morality concept. It's called 14, CP14, and it deals with several names, like those names related to marijuana. We have lots of them. We do not have MOTA yet. But we have a common front with all WIPO and national organizations in terms of applying these concepts. I think Mexico could copy the criteria we use for Pablo Escobar. Thank you.
Muy buenas las exposiciones.
Great presentations. Now I wonder, in a world where people graciously use the face of a criminal like Che Guevara on their clothing, and nobody is affected by that. And when we are discussing here whether this may be registered or not, there is absolute freedom to use that trademark as anyone may want. So what's the use of what we're discussing here? Well, I agree. There's a clear difference between requesting the registration of a trademark and what a person may wear. A T-shirt with no registration, no trademark. That's something that is outside trademark registration. But I agree that a trademark should not be requested if it includes the face of a serial killer, a dictator, where obviously there is a negative connotation, there is apology for a crime, and we should not be complimenting these people and taking these messages to more vulnerable populations. I don't think that rejecting registration of a trademark of a killer or a drug trafficker is restricting freedom of speech. But I do believe that if we grant that registration, we are supporting drug trafficking, drug culture, and we should not be conveying that message. Not because the government is not doing its job, not because of that we should neglect this. If we all do what's right for the society at large, then that will be good for all of us. It's not about saying this is not my responsibility, this is something the government should do, this is not my business. This is somebody else's business. I think we do have to take ownership of these situations, of these trademarks, and we should reject these marks, and this does not mean that we are restricting freedom of expression. I'd also like to add something about the European practice, because we've talked a lot about criminals and people associated with crime, but you cannot either register trademarks associated with positive figures like presidents or products and services that may be pejorative towards those figures. For example, there was a case with the brand Tattoowork in the European Union. When people try to degrade or be pejorative towards these brands, then these trademarks cannot be registered either. You always have to consider products and services that are requested. Imagine the Nelson Mandela trademark or Gandhi for toilet paper. That would be pejorative towards the importance of these international people. However, if you were to request a trademark for education services or museums, then that would be possible. So you always have to analyze case by case, and you have to focus not only on the crimes, but also on the potential degradation of the public figure. As I said, in the States, you can register whatever you want. So Gandhi for toilet paper may be registered. It cannot be a living person. I don't agree with that, but that's what the situation is like in the U.S. Thank you, and congratulations to the speakers. I just wanted to mention a funny thing that came to my mind when I was listening to Alejandro's presentation. Some weeks ago, I attended the 50 Congress in Naples, and the Congress opened up with Simon Dang, this dance plaintiff. This is a case mentioned by Alejandro, and he told the story of all those years he fought for his brand, and that was associated with musical performance. He had prepared songs that told this story in a very nice way, in a very artistic way, and he told all his legal struggles through music and a print document that he shared with us. And there is also a nice story of inclusion, because he struggled for the minorities in the U.S. to have access to their trademarks. His trademark was not offensive. It just communicated the way he felt. And I think his struggle ended up with quite a relevant result in terms of the future of these trademarks in the U.S. Are there other questions from the audience? As I've already said, if you cannot think of any questions now, you can talk with the speakers later on. Thank you all for participating. Thank you again to Desiree, Octavio, and Alejandro. Thank you.